heard a lot about parking charges this morning, but the question most drivers want answering: if you get one from a private company and you think it's unfair, do you actually have to pay it? To answer that, we've turned to today's expert in residence, Professor Margaret Griffiths.
These scary-looking notices are not fines. They are merely invoices for a breach of contract. They may look a bit like those issued by public authorities, but they're very different because there is nothing in criminal law to support a charge or fine for parking on private land. So let me explain how they work. Now, when you first enter a car park, you're really entering a contract and agreeing to any terms that the car park owner may have laid out about, for example, how long you can stay or any pay and display requirements. Now, their requirements must be clearly displayed on a notice when you come into the car park and possibly at other points around the car park, including any car park charges that are payable and any other charges to which you may be liable if you breach the conditions of the contract. And remember, the notices must be clearly visible, so they mustn't be behind a tree where you can't see them, or, for example, be so dirty that you can't read what they say. So if all of that's in place and you breach the terms, then you can expect to be charged. But what matters is that the charge can't be disproportionate to the loss that the company has actually suffered, plus some admin charges. Bottom line, the charges should not be astronomically high. So, what if you get one of these notices when you know you weren't in the wrong? Because, for example, either the meter wasn't working or the signs weren't clear. Well, then you could have a very strong case for an appeal. So here's what to do. Contact the company at the earliest opportunity to tell them that you're contesting the charge. Ask them to provide proof of their case against you. It's up to them to prove that you breached the contract, not up to you to prove that you didn't. You can support your case with photographic evidence. So if the meter wasn't working or the signs weren't clear, take a photo. Then wait. To comply with the British Parking Association's Code of Practice, the parking company must acknowledge your letter within 14 days and give you a decision within 35 days. If you can't reach agreement with the parking company, then you can always take it to Parking on Private Land Appeals, or POPLA, an independent appeals process launched recently. But remember, if your appeal isn't successful, the company would still have to prove their case in court before they could take any money from you. And in practice, they're most unlikely to do that. But it's always worth getting some advice anyway from either the Citizens Advice Bureau or a solicitor.